Major breaking news, a huge win for President Donald Trump and his administration in the United States Supreme Court. A 6-3 decision written by Justice Amy Coney Barrett has just decimated the lawfare against President Trump that we've been seeing over these last 120 days or so. You're not going to want to miss this one. A big win for freedom in America right now. Hey folks, I'm Mark Smith, host of the 4 Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, this is huge news, something we've been anticipating. Today, the United States Supreme Court has just declared, as well it should have, that so-called universal injunctions, the sort that have been entered by these district court judges in the typical anti-American jurisdictions of New York City, Boston, San Francisco, Los Angeles, Maryland, D.C., are no-go, not allowed, unconstitutional, and illegal, and can no longer be used moving forward. Just as a reminder in this case, this is about birthright citizenship, which of course is the absurd notion that an illegal alien can come to the United States, pregnant or otherwise, and give birth to a child, and that child becomes a U.S. citizen automatically simply by virtue of being born on soil in America. And that serves as an anchor baby through family reunification processes to bring the rest of the family to America to enjoy the benefits of our welfare system. That's essentially how it works in the real world. So Donald Trump stepped up and issued an executive order saying that the proper interpretation of the 14th Amendment, from which this alleged birthright citizenship gives rise, it says that this is not the proper interpretation of the 14th Amendment, and that if you're simply here in America illegally, and the person is born to that illegal alien, that is not a basis for U.S. citizenship. The child of the illegal alien is also an illegal alien, and they can all be deported, and they do not have the benefits of being an American citizen. Now, this case today that was just decided, Donald Trump versus CASA, does not specifically address that substantive question. That will be dealt with down the road. Today's case deals with, in some ways, an even more important issue in the short run, which is whether or not a single district court judge anywhere in America, of which there's something like 600 or 700 of these district court judges in America, can any one of those judges enter what is known as a universal injunction, sometimes referred to as a nationwide injunction, but it's more accurate to call it a universal injunction, that says that even though I have like one person who's an alleged illegal alien or one group or a couple people, they can by extension enter an injunction against the federal government that prevents the federal government from enforcing that law, that statute, that regulation against everyone in America. So Mark Smith by himself sues the federal government over something I asked for a preliminary injunction that prevents the federal government from enjoining or prevents the federal government from enforcing that regulation, that rule, whatever it is, in this case, the birthright citizenship interpretation of the 14th Amendment by Donald Trump. And not only can I get relief as the plaintiff in front of the district court judge, but the district court judge would be entering an order that says that the federal government cannot enforce this law against Mark Smith and anyone else in America. This is a relatively new phenomenon, something we've just seen in the last maybe 20 years or so. So finally, this got to the point where the U.S. Supreme Court got fed up, as well they should, and said, we need to fix this right here and right now. Justices like Justice Thomas and Justice Gorsuch had previously said, this is crazy talk. We got to do something about this. And finally, the Supreme Court got off its dupa and did something big time today. 6-3 decision that says that universal injunctions may not be entered in the future by district court judges. District court judges can continue to enter temporary restraining orders, preliminary injunctions, and other forms of equitable relief, meaning telling someone what they can do or what they cannot do. But those orders can only apply or will only apply to the specific people that are actually in front of the judge involved directly in the case. Now, this is a huge victory because what's been going on is you have a couple people are suing the Trump administration to shut down the entire government apparatus on that topic in like Seattle or Boston or DC. And these judges have entered orders that said the federal government can't enforce the law anywhere against anyone ever. So you essentially have a federal district court judge, one of 700 or so, entering an order overriding the President of the United States. You essentially have given these judges a judicial veto over the President of the United States, which is absurd. And the Supreme Court finally stepped into this and said, no, man, dude, this is not appropriate. Now, that's great news. So the outcome is going to be that the lawfare we've seen against President Trump in the last 120 days or so is going to start to dwindle. Because while they might be able to get injunctive relief for like 5 employees at the Census Bureau or something like that, they're simply not going to be able to get universal injunctions against the Trump administration to cover tens of thousands, if not hundreds of thousands of illegal aliens, or hundreds of thousands of federal employees, or hundreds of thousands of X, Y, or Zs. The people are not suing if they're not actually in court by name or by virtue of their membership in an organization that's suing withstanding, they're not going to get afforded the relief. Which is great news because this has taken away one of the largest tools, if not the largest tool, that the so-called resistance movement to Donald Trump has been deploying this term. It has now gone bye-bye and a big win. But that's not the only great news out of this decision. The author of this decision, I know you guys are going to get mad at me, some of you out there, but I got to tell you the way it is. The author of this decision was Justice Amy Coney Barrett. Now, I've explained to you all, do not get on Justice Barrett's back. You can criticize her and complain about her opinions, but don't go too far because it's not justified. And don't buy into the hype. Don't buy into what other people say for clicks and other people say in terms of attacking Amy Coney Barrett. Don't play that game. It's a loser's game because A, it's not true, as we can just see from her massive decision here today. And wait till you get to some of the language she used about Justice Brown Jackson. We're going to get to that in a moment. You're going to get a kick out of that and see my point. But not only is it not true to say that Barrett is a terrible justice, that is simply not factually accurate given her major decisions in our favor on many issues, including this one today in favor of President Trump yet again. It's also stupid because, again, Justice Barrett and many of these justices are going nowhere for the next 30, 40, 50 years. So why would you try to piss them off to get clicks or to try to get watched on TV or something? It's not good strategy. Again, that's just my point of view. You can disagree with me. But with that said, Justice Barrett wrote this opinion for the 6-3 court, lambasting the other side as simply not having any good arguments. And I want to read you this quote because this is an astonishing quote from Justice Barrett attacking the views and the opinion of Justice Brown Jackson. Tell me if this sounds like something written by a squishy squish. I would submit it does not sound that way at all. Here's what Justice Amy Coney Barrett wrote about Justice Brown Jackson just now in the Donald Trump versus Casa case. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary. Woo! That is some tough language. And that's not like the dissent. That's not like my learned colleagues. That says Justice Jackson's argument by name. Ooh, not good. But it's actually very good for America and the Constitution to see what Justice Barrett wrote about Justice Jackson. Keep this in mind. Again, I'm only telling you, don't screw around with the Justice Barrett stuff. It's strategically stupid. Don't do it. It's not good. Criticize appropriately, but don't go overboard. That's all I'm saying. Now let's carry on. There's also very good decision-making here and very good for the Second Amendment. Okay? You're like, how, Mark? How is this good for the Second Amendment? In addition to the fact that this is going to help the Trump administration advance their agenda by not getting bollocksed up in this crazy lawfare that has been brought repeatedly by the anti-Trumpers, there's some very good language here. Specifically, as you know, one of the issues in the gun control fights we have in the Second Amendment litigations is the relevant time period to determine when to assess the meaning of the Second Amendment, the assess of a law, whatever it is. And the right answer is 1791, and the anti-gunners want it to be the late 19th century because there's more gun control laws then. So they want it to be when the 14th Amendment was adopted in 1868. But the good news here is the Supreme Court is again going back to the founding of the United States to try to assess what was the understanding of Article 3 of the U.S. Constitution, which created the Supreme Court and the so-called inferior courts, including district courts, pursuant to acts of Congress. So the point being that this court goes back in time, again, right around the time of the founding, to understand what the founders of our country, the writers, the people that ratified the U.S. Constitution, what were they thinking about the powers of the courts, including federal district courts, and whether our founding fathers thought that a single federal district court could have the equitable or other authority to enter universal injunctions to say that even though Mark Smith is the only person suing, I'm going to enter an injunction in favor of Mark against the federal government, and I'm going to have that apply to everyone in America and not just Mark, even though the only person in front of me as a federal district court judge is Mark. And the Supreme Court looked at this carefully and looked at the history and said, there is no historical basis at the time of the founding to reach this conclusion that these courts had that kind of broad equitable power, and therefore we're not going to recognize it today in the 21st century. Check out what the court wrote, touching fingers with this exact point. A universal injunction can be justified only as an exercise of equitable authority, yet Congress has granted federal courts no such power. The Judiciary Act of 1789, endowed federal courts with jurisdiction over all suits in equity. And still today, this statute is what authorizes the federal courts to issue equitable remedies. Though flexible, this equitable authority is not freewheeling. We have held that the statutory grant encompasses, listen carefully, folks, listen carefully, very important. We have held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded by courts of equity at our country's inception. Hear what I just said? At our country's inception. The court goes on to say, we must therefore ask whether universal injunctions are sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of our Constitution and the enactment of the original Judiciary Act. Fantastic. Fantastic. Here you have the Supreme Court teaching American lawyers and pointing out that if you're trying to understand the original meaning of the Constitution, you don't go airy-fairy, reading, novels in the 21st century and trying to see what the editorial pages of the New York Times tell you to do. No, you go back to the time that the document, the Constitution, was adopted and ratified, and you try to understand what it was intended to do, what was the meaning as understood by the people, meaning we the people, because we the people adopted the Constitution. So they look for historical evidence, including the English equitable history from courts of equity in England, known as chancery courts in many instances. We don't need to get into that history for our purposes today. But the point is they looked at English history of equitable relief. And just to be clear, just so you understand the difference, when you talk about legal relief is about payment of money. So if I sue you for money and you have to pay me money, that's really called legal relief. That's a legal remedy. If I'm seeking what's known as equitable relief, that is the court telling you or me to do something or not to do something. So if it says, pay Mark $100, you lost the lawsuit, that's a legal remedy. If it says, don't come within 1,000 feet of Mark and sign over the title to your car to Mark, that's an equitable remedy, because in equity, the court's telling someone to do something or not to do something. That's different than the payment of money. Legal remedies are payment of money. Equitable remedies are basically all that other stuff about, go here, go there, do this, do that. Those are equitable. And that's what we're talking about here today, because these federal district courts were telling the federal government in equity, don't enforce the law against anyone in America, even though the only person suing is like Mark or Bob or Jim. But that's what the courts were doing. So here you have a great situation where the court is going back in time. They're looking at the relevant English history that got imported into American law. in the various acts, including the Judiciary Act, and trying to figure out what it meant. And then they said, is there any historical analogies that would justify the existence today of these so-called universal injunctions? And having looked at the history at the time of the founding and the relevant law, they said there's no way, no how this is possibly constitutional, and therefore going forward, these district court judges cannot do this anymore, period, full stop. And I will just wrap up with this great quote talking about these arguments that say that you need these courts to go crazy against the Trump administration to check the Trump administration and prevent a rogue president from doing crazy stuff. Here's what the court says in addressing that, basically saying you can't let rogue judges exist to stop a perceived rogue president. That's not how our checks and balances work. Here's what the court had to say in summing up its opinion. Some say that universal injunctions give the judiciary a powerful tool to check the executive branch. But federal courts do not exercise general oversight of the executive branch. They resolve, meaning the courts, they resolve cases and controversies consistent with the authority Congress has given to them. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. All right, folks, so exciting news out of the Supreme Court, exciting news out of Justice Barrett. We got a lot of battles we're fighting. This is a big one to have won. We have more battles we're fighting every day all across this great country, including D.C. and the U.S. Senate. Let's see what happens with all of this. By the way, I will likely be on Fox News over the next several days. I'll keep you posted on posts on the channel or on X. With that said, you should definitely be following me on X at @ForBoxing Diner. Don't forget to also subscribe to this channel on YouTube and to Rumble. And I look forward to talking to all of you again real soon here at the Four Boxes Diner.
Orders up. Table 2A.